So Siew Kim's son, Marcus Chan, was left with properties in Jalan Ampang, shareholding in Bantap Awana, Sundiran Berhad, contents of all sale deposit boxes, and 30% of her residuary estate. In contrast, Xiao Li was left with just 900,000, while Kimberly got 100,000 ringgit. This is cited from a New Straits Times article on February 24, 2026. This is a case about the estate of Lim Siew Kim, the daughter of Tan Sri Lim Tong, who most Malaysians know as the founder of Genting. When she passed away, her estate was estimated at about 1.6 billion, including valuable properties and shares that trace back to the Genting fortune. Two of her daughters, Chan Xiaoli and Kimberly Chan, are now challenging their mother's final will in the High Court. They say that when the last will was signed in April 2022, she was battling stage 4 ovarian cancer on strong medication and did not have the mental capacity to understand and approve what she was signing. In other words, they are saying that the formation of the will was in circumstances that are suspicious. They are now asking the court to declare this final will invalid so that an earlier will, or the default rules of intestacy, would govern how the 1.6 billion ringgit is divided. So what are the default rules of intestacy? The Malaysian Distribution Act 1958 states that under this act, if a person dies leaving children but no spouse and no parents, then the children takes the whole estate in equal shares, meaning the money would have to be divided equally among the children. However, the major beneficiary of the will was Dikim Foundation, a foundation set up by Siew Kim and her late husband, who was named the major beneficiary under the will. So Dikim Foundation was the major beneficiary under the will, and they received over a whopping 70% of the residuary estate. Now, just because someone leaves a big chunk of their estate to a charity or a foundation does not automatically mean something suspicious is going on. There is a famous UK Supreme Court case, Ilott and the Blue Cross and others, and in that case, a mother left almost her entire estate, about 486,000, to 3 animal charities and gave nothing to her only daughter, with whom she'd been estranged for nearly 400 years. The Supreme Court ultimately upheld the idea that testamentary freedom still matters. One implication of this is that English law generally respects the testator's right to leave money to charities, even if that means disinheriting family. So what do you think happened in the case? Some suspicious circumstance or well thought out planning by the mother on how to responsibly distribute her wealth after her death, intentionally disinheriting her kids, or something else? Let me know in the comments.